Hey guys, welcome to this video. I want to do more of this here in the coming weeks where we'll take an actual court case. Like this is the Hyundai case out of Southern District of Florida decided March 25th. And I want to just actually walk through the opinion with you because I know that some of you guys are interested in that. This has to do with the Tcpa, so the Telephone Consumer Protection Act, which that's a law that prohibits people from using auto dialers, robo dialers against your phone if you didn't give them permission to. And it's a pretty neat statute because when these guys violate the law, it can be $500 up to $1,500 per call. And so we've had clients with hundreds and hundreds of calls, so you can kind of do the math. See, that's a really nice case. And then when we have folks that maybe just have 2 or 3 calls, then we do that as a class action because they're not just calling one person, they're calling 1,000 people or 10,000 people, 1,000,000 people. And what we'll talk about today is a little bit of a twist on this. It's what's called the ringless voicemail. And so your phone never rings, you just look down and go, I got a voicemail. And you listen to it and you go, that's strange. And you check back, no missed call. And so these companies, particularly car dealers, that's what this is. This is a particular car dealer. They are doing this just to everybody in the metropolitan area. And the reason they do it is they say, well, it doesn't violate the TCPA, this Telephone Consumer Protection Act, which really turns on, did you provide consent? Here's their argument. We never made your phone ring. See, it's ringless voicemail, so you can't sue us. We can just blast these things out to anybody we want as often as we want, and there's nothing you can do about it. That's their argument. And you're starting to see now with some cases that judges are going, well, I'm not sure that that's right. So like I said, this is the Hyundai case. And this is what's called a motion to dismiss here. And so all a motion to dismiss is where the defendant says, look, take everything the plaintiff says is true, they still lose, 100%. We don't need to go any further in the case. And so if the judge agrees with that, judge throws the case out. And so as I mentioned, this is under the TCPA. And this is the message that is being left. And I'll let you read this. And you may have seen this with, you get an email or you get a letter. Sometimes the letter is a printed out email. And it's basically like, hey, we're dying to get your car. It's just in such hot demand. And you got to come see us and we'll get you a new car for cheaper. That's what the message basically says. And so the plaintiff alleges that, hey, I never gave consent to call. I never told you could do this. And so then the next part of this opinion, this ringless voicemail, the court explains what it is. So basically, your telephone number is identified with a voicemail box. And then these pre-recorded messages are inserted into each voicemail box en masse. In other words, not just one at a time, but there's 1,000 or 100,000 of these that go out to 100,000 different people. And so this says it's essentially the same method used to transmit text messages. And your phone doesn't ring, but when that voicemail goes in your box, it certainly makes a noise, or you look down at your phone and it says you have a new voicemail, or however your phone is set up. So the plaintiff has sued saying, hey, this actually harmed me and it inconvenienced me. And, unlike even robocalls and text messages, I'm powerless to block this. See, if we get a call from a telemarketer or somebody spamming us, we can just click block. Now they can change their phone number and, try to get through that. But the point is you can ignore it. You can tell them to stop. But here it just goes directly into your phone. And so the plaintiff says you violated the TCPA. And so this is an artificial or pre-recorded voice. So remember, this wasn't a live message here that we have highlighted. This guy recorded it once and then it just got deposited into 1,000, 10,000, 100,000 voicemail accounts. And then count 2, they say this was not just an accidental violation. This was a willful or intentional violation of the law. The significance is if it's intentional, it can be up to $1,500 per call. So you kind of do the math on that. if they called 1,000 people, 10,000 people, that can get very expensive for them. So the defendant moved for a dismissal under Rule 12b-1 and 12b-6. And then they also say this law violates the First Amendment. Kind of a goofy argument, but the judge addresses it. So this gets a little convoluted because there's some hot issues right now in federal court litigation. So I hope this will be interesting to you. But there's something called Spokio, and you can see that right here. Spokio is a Supreme Court decision that basically says if you're suing under a federal law and maybe you don't have actual damages, but you're saying, hey, they violated the law, I get statutory damages. Could be under the FDCPA, suing debt collectors, the FCRA related to credit reports, or the TCPA related to cell phones. Then the question is, do the doors of the court open up for you, or do you not really have an injury and therefore you're prevented from going to federal court? So that's the argument here. And this is the basic gist here is Article 3 of the Constitution says we've got to have standing to sue. And that can be injury in fact, it's traceable to the defendant, and it can be redressed or dealt with by the court. And so we don't want sort of hypothetical things where somebody goes, well, I think that truck company might run me off the road next week, and so I want to sue them. No, we don't go to court for that. And then 12b-6, this is the more standard motion to dismiss. It says, take everything that the plaintiff has said, accept it as true, and they still lose. And so to survive motion to dismiss, a complaint must contain factual matter accepted as true to state a claim for relief that's plausible. That's kind of the key word, plausible, on its face. And so then we come down here, and the issue is, did the plaintiff actually receive a call? And so I think the judge puts this the right way. The heart of the matter is whether a ringless voicemail is a call within the TCPA. And so that's the question. Now here's the defendant's arguments. So they make two arguments here. First, they say, we didn't make a call. I mean, did your phone ring? No, it didn't ring, so that's not a call. And then they say, because it's not a call, you have no interest to protect, and thus you have no standing, and thus you get kicked out of court. Just as a side note, this is one reason why we almost always bring these cases in state court. Now, defendants can't stand to leave them in state court, because the idea is that federal court is more friendly to big business. It's not really, but that's the idea. And so they remove the case from state court to federal court. Well, then when they make these arguments, we go, okay, that's fine, let's go back to state court. If I can't be in federal court, I go back to state court. And the lawyers go, oh, well, we didn't think about that. Never mind, you can stay in federal court. So they don't want to go back to state court. But if you file directly in federal court, then you face these types of arguments. So, again, it gets kind of technical. Is this a factual, or what type of argument is this? And just look at this part, because I think this is interesting, what the defendants argue. And they say, ringless voicemail software connected directly to the voicemail server deposited directly in plaintiff's voicemail, thus bypassed any contact. And so that's really the heart of their argument here. And then they say ringless voicemail does not qualify as a call. And so they say, therefore, the plaintiff's case ought to be thrown out. So the judge says, okay, well, is ringless voicemail a call under the TCPA? And so this judge is very methodical in going through this. And he says, all right, well, let's look at the word call, because that's really the question. When this law was passed, several decades ago, it just talked about call. But we didn't have text messages then, and so the court's going to look at that as well. And so in Satterfield, this is a case out of the Ninth Circuit, which is the West Coast, think California. The court said the definition of a call was to communicate with or try to get into communication with a person by telephone. Pretty simple definition here. And then other courts have agreed with that. And so that one said a text message qualifies as a call because you're trying to communicate with somebody. And so courts have consistently held voicemail messages containing pre-recorded messages subject to TCPA restrictions as traditional calls. All right. And then this is important. Courts, let me just highlight this for you here. Courts have also found TCPA does not distinguish between calls that are picked up and calls that go to voicemail. And so the argument used to be, well, if you didn't answer, well, then that wasn't a call. Even though I made your phone ring and I put a voicemail on there, if you didn't answer, that's not a call. Court goes, no, there's no obligation to answer. The fact that somebody has reached out to your phone is enough. And so here we talk about text messages. And the court points out that text messages are calls and is undisputed, qualifies as a call within this law. And the 11th Circuit, which is the appellate court over Florida, Georgia, and Alabama, this is a case, the Murphy case, prohibition against auto dial calls applies to text message calls as well as voicemails. And the court noted that, look, we didn't have text messages when this was enacted in 91, so we look at the purpose and the history to try and decide this. And so here the plaintiff, now this is the plaintiff's argument, says they employed a program, Ringless voicemail, communicate with the plaintiff. And they deposit these en masse to non-consenting consumers. And so the court says the fact that the telephone does not ring as it traditionally would is not significant to determining whether the call qualifies. And the reason is because it doesn't matter if you answer the call or not, so what difference does it make whether it rings or not? And that's what the court's saying. Rather, it is the mere act of placing the call that triggers the statute. And so here we go. The ringless voicemail is no less intrusive than a standard voicemail. All right. And then the court goes, well, how does this conclusion fit with sort of the purpose of the law? And it says, hey, it's consistent with why they passed the law. It was to address certain invasive practices, unrestricted telemarketing, unwanted intrusive calls, nuisance, invasion of privacy, and it's the only effective means of protecting consumers. Now look, if you have a cell phone, you know this is true because you get like daily these calls that just come in about lowering your credit card, you're getting affordable health insurance, and most of these are scams, but they're all illegal. And so then the court goes to, okay, well, let me just show you. Accordingly, the court finds that the ringless voicemail is a call. Now the court goes, well, is that enough to open the doors of the federal courthouse? And remember, if you file suit in state court, and if they remove you to federal court, you don't have to deal with this because if you get kicked out, you just go back to state court. And so the court points out defendants' arguments in support of their proposition or focus on whether ringless voicemail qualifies as a call. But it says, hey, I've already decided that. It is a call. And so you have Article 3 standing because plaintiff sufficiently alleges an injury. All right. And some of this I'm going to skip over because it gets a little convoluted with this whole Spokio stuff. But I want to drop down to this. Whether plaintiff states a claim for violation of TCPA. And so again, the defendant's arguing that this was a call without any support. And the plaintiff says, well, look, you transmitted this unsolicited voicemail, pre-recorded message to me. And the court says that's enough. And then we have this kind of goofy argument, TCPA must be struck down as violating the First Amendment. And the basic argument, let me just show you here, that preventing phone traffic, protecting privacy of cellular telephone user, not compelling interest, not narrowly tailored, and you just got to get rid of this whole law. And, you know, a lot of times defendants do this. They'll suddenly say the FCRA, Fair Credit Reporting Act, or the Fair Debt Collection Practice, that violates the First Amendment because we ought to be able to say whatever we want to. And those just don't get anywhere. And so the court goes through this analysis and says, well, you have the right to challenge this. And the court ends it with this. Because court concludes provision survives strict scrutiny, it would also satisfy any less searching standard of review. Basically, when somebody says a law violates the First Amendment, there's a really strict approach the courts use or a less strict. This court said, let's apply the strictest approach. You lose. The law stands. And so the court goes, I'm denying that. Now here's the part about knowing or willful. And again, this is important because you can basically triple your damages up to $1,500 per call. And so the court points out can receive actual monetary loss, which is very rare, or receive up to $500 damages for each violation, whichever is greater, and it can be increased to an amount equal not more than 3 times. Okay, and so here's the test right here. And again, this is from the 11th Circuit, that the violator, so Hyundai, the car dealership, they have to know they were performing the conduct that violates the statute. It doesn't necessarily mean that they go, I know this is violating the law. It's, I know what I'm doing here. In other words, they didn't accidentally call 10,000 people. Like somebody pressed F5 on their keyboard and said, oh my goodness, I meant to delete that, not send 10,000 voicemails. No, they knew what they were doing. It's very deliberate. And so plaintiff alleges transmitted pre-recorded message to plaintiff members of the class. They did this knowingly, and this was an attempt to circumvent the TCPA by using this ringless voicemail. And so here's the conclusion of the court. It's worth looking at. And so may be awarded court's discretion. It would be inappropriate at the motion to dismiss stage to exclude the possibility of the court making such a finding. See, there's been no discovery. Nobody's had to raise their hand and swear under oath. The plaintiff has filed their complaint, and the defendant saying, well, you didn't allege that we did this willfully. And the plaintiff goes, yeah, I did actually. And the defendant comes back and goes, well, you didn't offer any proof of it. Well, see, we don't get the proof until we get people raising their hands, swearing under oath. And so the court goes, no, I'm going to deny that. And so, again, a very important case. This is really only about the second case in the nation that's addressed this ringless voicemail. It's going to start becoming more and more popular. You're going to get these calls. If you've gotten them, in other words, you look down at your cell phone, you go, I didn't miss a call, but I got a voicemail. And you listen to it, and it's this pre-recorded message, but there's no missed call. It could be just some glitch, but it probably is this ringless voicemail. And definitely get in touch with us, really wherever you are in the country, because we can file these in Alabama or we can file them in other places. Typically, we do these as a class action. And so if you're in another state and we can't file in Alabama, we'll get with a lawyer in your state. But definitely save the message. Get in touch with us, 205-879-2447. Or you can go to our website, and if you just, let's see if I can get this, my keyboard work, contactjohnwatts.com. That'll just take you to this portion of our website that has this contact page on it, and you can call us or you can click this form down here, and then that will let you tell us what's going on, then we'll get back with you. So we just set that up, try to make it easy. So just contactjohnwatts.com. And hope you like this. If you do, please let me know, and I'll do more of these sort of case law videos where we actually go through the court opinions. And appreciate you watching this, and talk to you soon. Bye-bye.